Objection sustained, the judge says. Objection overruled, another judge says. Your Honor, we make a motion for summary judgment. Have you ever heard these phrases before? And if so, do you really know what they mean? Come join me as I share with you exactly what they mean. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. You know, you've probably heard these phrases before many times in the movies, watching a TV show, on the news, reading the paper, and you may not truly understand what these words mean. But I want to share with you exactly what they mean, especially when you hear them in court if you're going to visit or you have a particular case that now you're involved in. Objection is when an attorney jumps up and tells to the court, "Objection, Your Honor," and now he has to give the reason why he believes a question is not properly being asked or it's not properly being phrased. And now the judge has to make a snap decision about whether or not to allow the attorney to ask the question and whether or not to allow the witness to answer that question. If the judge says objection sustained, what that means is, Mr. Attorney, you cannot ask that question. Mr. Witness, do not answer that question. Now, what does it mean if the judge says objection overruled? Well, it now means that the attorney who has objected, that the judge does not agree with that lawyer and instead is saying, listen, that objection is not appropriate. Mr. Witness, you can go ahead and answer that question. Now, when you hear an attorney say, Your Honor, we make a motion for summary judgment, first you have to know what is a motion. A motion is a request by one attorney to the judge to do something. And in all likelihood, it's not going to be very pleasant for you if this is your case. So the attorney is asking the court to actually take action on something that's happening during the course of the case. A motion for summary judgment means that all the evidence is now in on your case for the injured victim, and now the defense lawyer is standing up and say, Judge, we don't believe that the jury should be allowed to go ahead and make a determination about whether or not this injured victim is right or they're wrong. So now the judge will have to make a decision, either verbally or orally, or have to tell the attorneys, listen, I can't decide this just on your oral argument. Instead, I want to see papers, I want to see reasoning, I want to see arguments, I want to see case law that supports your argument. And then the judge will have to take time to come to a decision or a conclusion about whether or not he agrees or disagrees with the lawyer who is asking the court to throw out your case. So why do I share this with you? I share this with you just to give you an insight and an understanding into what goes on during the trial process, because in all likelihood you're going to hear these phrases come up over and over again when questioning of witnesses. Objection sustained. Objection overruled. Go ahead and answer the question. Your Honor, we move for a motion for summary judgment. Denied. Next witness. So all of these things will come up during the course of trial, and today's video is just for the purposes of giving you a quick explanation to give you a better understanding of actually what goes on during the trial process. You know, I realize you're watching this because you probably have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski coming to you from New York. Have a wonderful day.